Thank you so much. I think the earlier panel demonstrates why we do this in the form of a debate. I think the concept of a debate really brings out what's the most important points, and I think we can look forward to something the same thing now in the second debate, where we're going to be discussing whether the rule against double hatting will impede the generational change in ISDS. Moderating this panel is Mia's own Katharine Menéndez de la Cuesta at Holland tonight. Really come from Spain, but that's okay. She's now a local in Miami. How long she's already been here. But thank you so much, and Katharine, you can take it from here.
Thank you, Luis. So good morning, everyone. We hope you're having a great time in Miami so far and enjoying our very first Miami Arbitration Week. I am honored to moderate the second debate of the conference. The proposition that you can read on my back is timely and, of course, controversial. A rule against double hatting will impede the generational change in ISDS arbitrators. What is double hatting? Double hatting is generally understood in the context of ISDS as a practice by which one individual acts in different capacities, different roles in ISDS cases simultaneously or within a short period of time. It is usually as counsel and arbitrator, obviously in different cases, but it can be also as counsel, an expert or mediator. The discussion is most properly framed in terms of independence and impartiality. Many of you may know that the Secretariats of Ancestral and ICSID have been years collaborating in a code of conduct for arbitrators in investment disputes. The code is intended to provide applicable principles and provisions addressing matters that are important in the field and sometimes can be difficult to handle. They touch on things like independence and impartiality, or the duty to conduct proceedings with integrity, fairness, efficiency, and civility. The first version of the code was published in May 2020, and after all these years, in October 2023, an advanced copy was released following the comments by the Commission in the last meeting in session, 56th session that was held in Vienna in July. The reason why we bring up this code of conduct is because Article 4 proposes some limits on multiple roles in ISDS. And just to frame this discussion, and because the articles has been used by our speakers as the basis for some of their arguments and points, I'm going to read it out to you, and my apologies to those of you who already know what it says. Article 4, the title is Limit on Multiple Roles. It says, first, unless the disputing parties agree otherwise, an arbitrator shall not act concurrently as legal representative or an expert witness in any other proceeding involving the same measures, the same or related party or parties, or the same provisions of the same instrument of consent. Number 2, for a period of 3 years, a former arbitrator shall not act as legal representative or an expert witness in any other international investment dispute or related proceeding involving the same measures unless the disputing party agree otherwise. Number 3, for a period of 3 years, a former arbitrator shall not act as legal representative or expert witness in any other IID or related proceeding involving the same or related party or parties unless there is an agreement by the parties. And number 4, for a period of 1 year, a former arbitrator shall not act as a legal representative or expert witness in any other IID or related proceeding involving the same provision or provisions of the same instrument of consent unless the disputing parties agree otherwise. Some, including delegations of Ancestral Working Group 3, have raised concerns that an outright ban of double hatting would limit party autonomy or decrease the pool of arbitrators available, and adversely affect diversity. It is true that the code attempts to minimize such effects, and instead of clear rules or outright bans, it tries to address these conflicts of interest that are of greatest concern. There are some issues, though, that the current draft creates, or that some say that the current draft creates, and I don't want to go into a lot of detail to let our speakers run the party. But obviously today we're going to focus on something very specific, which is generational change. We agreed that this generational change includes gender and generational diversity. While some believe that the ability to accept arbitral appointments while we maintain our work or our role as counsel in a law firm may help some people or some practitioners accept the appointment, and that way it can increase the pool, because otherwise we would not be able to just leave the work we are doing to only be arbitrators if we've never been appointed. Others believe this is a problem, and it will actually have the opposite effect. Others think that by forcing a limit or imposing a limit in double hatting, we are going to reduce the ability of the old ones to accept appointments, and that's going to force the entry of new ones to the pool. So it is controversial, and to debate this proposition today, we have four fantastic speakers. In favor, we have Mélida Hodgson. She is a partner of Arnold & Porter based in New York. She is a recognized arbitration practitioner and arbitrator, especially in Latin America. She has over 30 years of experience practicing in our field and has represented clients before all major institutions. Her areas of expertise are infrastructure, construction, mining, transportation, energy, and business combustion disputes. Also in favor, we have Andrés Moreno. He's a partner and the leader of the international arbitration practice of Moreno Baldivieso in La Paz, Bolivia. He has extensive experience in matters under the rules of all major arbitral institutions too, including representing the private investors in the single most important investment arbitration in the history of Bolivia. And currently he serves as a member of the International Court of Arbitration of the ICC. Against the proposition, we have Elisabeth Eljuri. She is an independent arbitrator and energy specialist. She regularly sits as arbitrator in major international arbitrations, commercial and investment, related to Latin America. With over 30 years of experience in the region, she is considered a leading authority in the areas of energy, natural resources, and major projects. And in addition, she is an executive in a private equity-backed oil company based in Houston. Juan Carlos Castillo is Senior Managing Partner of Aguilar Castillo Loft, based in Guatemala. He regularly serves as arbitrator in complex international arbitrations related to Latin America, particularly involving infrastructure, energy, and natural resources. So with this stellar panel, I hope and I'm sure we're going to have fun. So we're going to start with the introduction of the position in favor of the topic. I think Mélida is going to start. So Mélida, why will a rule against double hatting impede generational change?
Actually, Andrés is going to start.
Oh.
Thank you. Well, very, very quickly, thank you very much to the University of Miami for the invitation, and to MIAS, which I think it's an exceptional incentive for bringing us together on a Sunday morning. In the next couple of minutes, I'm going to address in favor of the proposition based on four different perspectives. For one single instant, imagine yourself as a young lawyer, knowledgeable, deeply involved in investment arbitration. You have speaking engagements, you write articles, you attend to conferences, you want to pursue a career in international arbitration. And suddenly, out of the blue, you receive your first ever appointment as arbitrator. What do? Two alternatives. You accept, knowing that pursuant to Article 4 of the recently enacted Ancestral Code of Conduct, Your work as counsel may be seriously restricted for the period that that case lasts, and even for up to 3 years after the mandate has concluded, or you decline, knowing as well that that golden opportunity might not come again. You never know when or if you will ever receive a second appointment. So what do you do? The truth is, it doesn't matter what you do. It doesn't. A rule of this nature will impact negatively the young professional one way or the other. Independently of the decision he makes, his career could be halted because he has to make a critical decision, perhaps at an early stage or a mid stage of his career, but he has no choice. It's due to the ruling. Arbitrator or counsel? Counsel or arbitrator? Article 4 does try to regulate double hatting, that is true. But what it's really doing, it's putting young talent and young practitioners against the wall with no need. Secondly, experience. Dealing with states, dealing with investors, their complexity, their bureaucracy, matters such as knowing international law, standards of investment protection, damages, etc., all share one common ground: experience. At the time of making appointments, states or investors will heavily rely on the experience of each candidate. That is a fact. Unexperienced arbitrators are rarely appointed, so gaining experience in order to be prepared for that role is absolutely key. Undisputed. The measures under Article 4 severely restrict the possibility for young arbitrators to gain such experience, and it cuts both ways. If he accepts the appointment, his ability to gain experience as counsel will be severely undermined. Having experience as counsel, knowing how a lawyer thinks, acts, reacts, knowing when he's serious or when he's actually pushing the line, is valuable experience that will actually prepare you to sit down as an arbitrator. You'll be deprived from that experience, at least from a very long period of time. What happens if you reject the appointment? Well, if he rejects, he will never truly obtain the battleground experience as sitting as an arbitrator. The golden ticket opportunity will pass in front of his eyes, and he will not be able to discuss with his co-arbitrators merits of a case, facts around the case, what is important, what is not important, how to reach consensus and solve issues. So a rule against double hatting in the way it is structured right now will most definitely, in our perspective, frustrate young professionals, and it will jeopardize them from gaining professional experience. Indefinitely, a rule of this nature will likely benefit, one, the appointment of unexperienced professionals, and perhaps non-conflicted professionals with non-counsel backgrounds, such as university professors, for example. So at the end, parties will go back to square one. And it's based on the reappointment of experienced and well-established arbitrators. Old guard arbitrators' appointments could be systematic. Why? Because parties, states or investors, heavily rely on experience. 3, barriers of entry. According to Allen and Overy, a very interesting study of Allen and Overy published by ICSID, an investor-state arbitration case lasts between 3.5 to 4.5 years. In practice, it's even longer, and we all know that. If you actually add 3 years in addition to that, that could be possibly affect based on the restriction of Article 4. This means that young arbitrators could be benched, sidelined, for a period of 5 to 7 years before they can actually act as experts or counsel again. This is a huge price to pay and is a huge barrier of entry that could easily destroy the young professional's appetite to pursue a career as arbitrator. Second, given the lack of certainty as to when their next appointment will be, arbitrators will need to be financially stable in order to pursue careers as arbitrators. What does this mean? Only those who can afford it will be able to serve as arbitrators. Again, creating a direct barrier of entry against young professionals. Third, relationships between young professionals and law firms could deteriorate. Young partners who dare taking up an appointment could have a very difficult time with their firms or practices. Arbitrator appointments will not be attractive to law firms, will not be considered sexy by law firms. Lawyers will generate less revenue because they're side-benched. And personal relationships, while they are not allowed during the time period they're restricted to actually participate, personal relationships with clients and contacts could deteriorate. So there's a high chance that firms will lean to retain non-compromised talent, and perhaps, some firms with strong counsel practice could even ban their partners from accepting such appointments. Lastly, a restriction of this nature is absolutely certain that will be economically discouraging for young practitioners. Young lawyers at early stages and mid stages of their careers need to generate income in order to survive in a highly difficult field. They have professional needs, they have family needs, they have professional needs, every type of needs. The truth is that young arbitrators will most likely relinquish these appointments because of these restrictions due to the possibility that their income as a lawyer, as a stable lawyer, will be seriously compromised. So in summary, only a few will afford to pursue a career in arbitration. Article 4 will restrict young lawyers from actually gaining valuable experience. Barriers of entry is not in question. Barriers of entry will benefit only the ones who have well-established careers. Article 4 intends to regulate double hatting. However, young generations will pay the price by limiting or even relinquishing their careers. And one final thought. A lawyer wants to be an arbitrator, but cannot work as a lawyer to become an arbitrator. And this makes little or no sense. Thank you so much.
Thank you, Andrés. Elisabeth, why do you think that a rule against double hatting will not impede generational change?
Thank you. Well, very happy to be here, and we're going to make a lot of provocative and unpopular remarks based on the proposition that we stand for. And in a room full of lawyers, it's not easy to say this, but please don't take it personal. We're here to have fun and to have an educational experience. So we've been hearing all the fantasy speculation from our co-debaters, and we're now going to come and talk to you a little bit about what the truth and the facts surrounding double hatting, what it implies, and especially, is it really the cause of this lack of the generational change that is missing in ISDS? So if we're not going to go into the task of inquiring whether double hatting is good or bad. It's in Article 4, we take that as an assumption, and we're here to say if it's here to stay, first of all, it's a temporal prohibition, it's a limited prohibition, it's temporal, as you heard from our moderator, and it's limited because everything is permissible with the permission of the parties or the approval of the parties. Now, our first proposition and disagreement with our friends and co-debaters is the whole idea that, in fact, this young, as was described, this young lawyer's whole career was frustrated. So the first thing we'd like to call your attention to is this is a debate about ISDS and only ISDS. And in the context of ISDS, it is our proposition that you have to be of a certain age to actually sit as arbitrator in these disputes. We believe the reputation, the maturity, the strength of character, and the experience that is required from an arbitrator in ISDS implies that it will be a person of certain level of professional experience that certainly doesn't fit the example that was presented for you in a binary proposition of a good or a bad. Now, to be clear, a generation, which is a question today, if there's going to be a generational change, a generation is 20 to 30 years. So essentially, we're talking about ISDS today being basically controlled by baby boomers and Gen X's. And the question is, why not allow the millennials in, and when will that happen? And baby boomers are, and I'm sure some in this room won't agree, but are somewhere approaching at some point the age of retirement. It's, let's say, from 65 to 100 years. So presumably some people will retire in that group. The second point we'd like to make is a law and economics type proposition, just to set the stage, which is there's an economic proposition that goes to the heart of some of the comments we were listening today. If a practitioner is in fact senior enough, based on the qualities that I just described that you want from an arbitrator sitting in an ICSID or UNCITRAL dispute, if that person is in fact senior enough to sit there, presumably that person already had a good, solid, long-standing career. And that person should therefore be able to afford to make the decision to step away from counsel practice and decide to be an arbitrator full-time. And I would just venture to say if that person cannot afford it, then he didn't really, or she didn't really have such a successful career to begin with, in which case there is no loss, talking from an economic standpoint. Now, we're going to turn to the specific points more directly related. No laughing is allowed, okay? I mean, from my co-debaters. You can laugh all you want. So our proposition is that actually double hatting is going to encourage diversity in age, in gender, and we're going to take these one by one. But why is that the case? It will force the system, the arbitral institution, the council, the companies, the parties to these disputes, the states, to seek a new and diverse pool of people who are highly qualified because of their experience in their careers and have reached the maturity level and seniority that I described to take on these positions. And they will be forced to expand their searches similarly to what we saw happened with the commitment to the pledge. And I have witnessed firsthand how this purposeful search to have more visibility, for example, in the case of gender, has proven to be successful. We see it today in the composition of these panels and conferences. We see it in the panels, in the arbitration panels of the recent appointments that you've been watching. Andrés also mentioned experience. Experience isn't lost. It's like riding a bike. You've practiced law for 45 years. Let's pick a number. Okay, you've practiced law for 20 years, and you've now decided that you want to be an arbitrator. We don't believe the prohibition deters that generational change, because we believe that when you do something full-time and you make that commitment to be arbitrator, you're actually going to be better at it. And I didn't make this up. If you read Outliers from Malcolm Gladwell, you know about the 10,000-hour rule. The more arbitrator positions you take, appointments you take, and the more cases you sit at, the better you will become as an arbitrator. And you will start to switch off that argumentative, I'm in favor and against that, mentality when you're counsel, and turn into that more even-handed nature of arbitrator, where you're meant to be impartial, where you're meant to look at the dispute for what it is without taking sides. So that experience will actually improve with the rule against double hatting, as modified, and as I said, temporary and pretty much, it's a modified version of a prohibition. It's not an absolute. Also, I believe that we have to recognize that the companies and the states have a role to play, which is to demand that there will be the proper appointments that don't sacrifice the generational changes that are sought at the right time. We're not here to talk about whether the code is right or wrong. There are a lot of scenarios there that we could go into it, and you'll see that it's not as harmful as it is implied. And not only because the parties can agree to waive this, but because of some of the ways that it was actually drafted. But having said that, and because we're not going to get to the core of what Article 4 is about, I would just say that what it does is important. And what it does is it's taken away the prohibition, or the very modified prohibition is trying to take away the discretionality and perception of bias that you find when you have a counsel arguing a very significant case that is very critical to the success of its client. And it's a case, for example, it's an argument about the umbrella clause. Let's just pick any random example. It could be jurisdictional, whichever. And the point that counsel has to make with the duty of loyalty to its client is XYZ on the umbrella clause. And then that same counsel at the same time is sitting as an arbitrator in a dispute where, as chair, has the swing vote to decide on the umbrella claim. And going one way or the other will lead to something that will be detrimental to the huge contingency fees that its firm had agreed to for the first case. So those are the types of perceptions, dilemmas that go to the heart of our ethical obligations that are trying to be addressed with a modified prohibition against double hatting. And another point that we'd like to mention briefly is that, first of all, the prohibition issues the similar ethical issues can be even raised about whether an arbitrator should be appointed for claimants and respondents, when some of the issues are sometimes on both sides of the spectrum. But we will stick to what the prohibition actually went for, which was counsel and expert work in parallel to arbitration, to arbitrator appointments. As to the argument of the younger generation not being afforded to quit legal practice, we do have some empathy. So our proposition is that we would not be opposed to there being some kind of temporal leave for first newly appointed arbitrator. For your first 5 appointments, you will be given some kind of leave where the prohibition is not absolute in your case. But that would be transitional, and it doesn't eliminate the need for the prohibition. It's just a transitional measure that is put in place to ensure that the system continues to flow. And lastly, in the last couple of minutes I have, I would just say I would be remiss if I did not talk about the issue of gender. And the proposition here that there will not be a sufficient generational change on the gender spectrum because of the modified rule of double hatting is a total exaggeration in our view. And I will just say this. The appointments from arbitrators and the senior people that we've described with experience are mirrors in terms of their experience, and the counsel that they would be sitting at, they should be partners in these firms, right? And the reality is that if you look at the last, 3 years ago, the ABA study, only 20% of the partnership in North America are female, and Latin America tends to be much lower. So the reality is there are no women arbitrators being appointed in their senior ranks, or not enough of them. It's because there are not enough women counsel in the law firms either. The issue is pervasive in the legal profession. It's not because of this rule of double hatting. Because these women, since they're not getting the exposure in the partnership, they're not getting the exposure to the partners in the other law firms who are deciding the appointments, and they're not getting the exposure to the clients who in the future will look at an appointment. It has nothing to do with the prohibition against double hatting. It's an issue that is endemic to the legal profession about how we can increase opportunities for women in this profession. Thank you.
Thank you, Elisabeth. We're going to now go back to the position in favor with this time, yes, Mélida, please.
Thank you. First, I would also like to say thank you to the Miami International Arbitration Society for inviting me to participate in this debate today. I'm not sure we gave our disclaimer that we were assigned these roles. We did? Okay, good. And that, the views expressed are not necessarily mine, my law firm, my clients, et cetera. And my apologies to those of you who can't necessarily see me over there, but you can hear me. So we basically heard that baby boomers are dying anyway, so everything will be okay. I think, however, that there's a little bit more finesse that we can give to this point. I'm going to start with the one on gender, that the Code of Conduct's rules against double hatting impede generational change, specifically with respect to gender. So in Elisabeth's ideal world, it's not just where we are. I mean, that's the reality. It's great that everybody now realizes, including ICA, that we shouldn't have manels. But that is very different from actually having the opportunity to sit as an arbitrator. There is no exaggeration. Yes, if we want the 20% to improve, then it's not just waiting for people to somehow catch up in law firms. We need to not create barriers to the entry as arbitrators. I think we can all agree that
Yeah, something is off. Wait. Her mic is off. Oh, okay. Yeah, mine works actually, so why don't you?
Thank you. Okay. Well, we'll keep this one. So I think we'd all agree that women make up at least 50% of the law school population, at least in the United States, and also junior classes. And yes, there are issues and developments at law firms, but the fact of the matter remains the two biggest pools from which arbitrators are fished, that is Europe and the Anglo North America. And so we can't create a rule that will impede their ability to be appointed as arbitrators. And it's possible also that the percentage of women legal professionals in the feeding pools of Latin America may be larger, but not at the partnership level. So Latin America, Asia, and Africa. But again, we need to not create the impediment, the ultimate impediment for these women. We also know that with exceptions, I think there are some in our field, most of the women have indeed come from law firms. And we know that those ranks, as you have explained, thin out at the senior levels when it comes to promotion to partnership or counsel. But this is where you get the most valuable experience. And this means first or second chairing cases and the opportunity then to get that first appointment. So while the code's prohibition is on restricting a quote unquote former arbitrator's ability to be counsel or expert, this has the effect of saying that if you happen to get one appointment, for example, in something like an ECT, European Charter Treaty type situation where it involves a regulation similar to the regulations that led to the stream of cases against Spain and other countries, then you can't serve in a related enforcement case. Where is the prejudice? If you're enforcing in a court, I don't see what that has to do with your ability. You're not sitting in judgment, you're sitting as counsel. Or for that matter, even a related commercial arbitration for, I was estimating 2 to 4 years, but as my colleague Andrés has pointed out, really it's more. It's more like 5 or 7, I believe you said, because it's from the time that your role ended. When does the role end? Does it end with the award? Does it end with people asking for rectification or something like that? It really is quite, it's not just temporal, it's really quite a long term. And again, these are not roles in which you would be the trier of fact. It's a role in which you're going to be serving as an expert or as counsel. So you're not sitting as an arbitrator judging the same issue that you would have judged. You're acting as an advocate. So, think about this. I mean, the Argentina cases, the Venezuela cases, these were situations in which there were specific legislations that led to the deluge of cases. I would venture to guess that many of us in this room got our start in those cases. And to say that someone could not be an arbitrator because they had one of those cases, I think it really is, particularly in terms of its effect on women, quite restrictive. In addition, as a senior non-partner lawyer, let's say, or junior partner in a law firm, you can't just park yourself for 2 to 3 years, 4 to 5 years, 5 to 7 years and say, oh, I can't work on those cases because I just served as an arbitrator. So effectively, it's a ban. And that then forces women to decide, are they going to leave the firm while they're still developing those skills? Because as you pointed out, you need to have the experience of complex cases, cases with similarly complicated issues, procedural issues. You don't get that until you're senior. That is called expertise, I believe, in our field. So, a reality check is that very few women are going to be able to develop the requisite expertise or experience if this option is taken out of that decisional equation. And there could be many reasons why someone is not rich enough to leave a law firm. Choices, you're entitled to those choices, or just that situations happen and that's why you're not able to necessarily leave and decide that it's worth the risk to sit and wait for one appointment every 6 months or something, and never mind when you actually get paid. So it just is not going to foster, it's going to impede what the code presumably wants to achieve, which is change in the investment arbitration world. Second, I'm going to talk about how the code's limitation stifles the development of a regionally diverse arbitrator pool. So let's look at this. I mean, to some extent, a lot of what I've said about how it stifles the generational change with respect to women also applies, or applies equally, when we're speaking about regional diversity. But in some ways, there's a worse impact, and it's due to 2 factors. Number one, we have a pretty dismal record of regional diversity in the arbitrator pool when it comes to investment arbitration in particular. And this is where a lot of the dissatisfaction with ISDS bubbles up. The perception that a club of pale, male, and stale arbitrators, and 2 to 4, maybe 5 women, are passing judgment on legitimate regulatory and other actions of countries in the global south. How does that look right? Without getting into cultural differences that perhaps are more nuanced diversity within certain of the regions, how might an arbitration practitioner or aspiring arbitration practitioner, never mind aspiring to be an arbitrator, sitting in Vietnam, Ghana, the Caribbean, and Central American countries feel about this limitation? Maybe it totally forecloses their substantive development and preparation for appointment first in commercial cases, which is the way it usually works, and then investment cases. So I think it really has a strong detrimental effect if we need to have regional diversity, which I think everyone agrees we do. Finally, I'll say a little bit about generational change and the effect that it has on diversity of thought. And again, building on my first 2 arguments, there is another negative result because the rule will limit diversity of thought or thinking, which is necessary for the development of international investment law and indeed international law. It's well known that diverse groups of people come up with better results and better solutions to problems. It can also be true, and I think it is true, in dispute resolution. Most of the people in our practice come from similar educational and perhaps social backgrounds. Just alone, if you stifle gender development in the field and regional diversity in the field, you're also going to have an impact on missing thought, diversity of thought. But that involves looking at not only at the underrepresented groups, as Ms. Moreno has mentioned, the newer, younger voices, but also just having different people sitting on, when you have a tribunal of 3, different experiences and understanding how those all come together. It's not going to be the same old way of thinking. And I think that, there can be no doubt about that. So for investment arbitration to evolve into a system or a regime that is acceptable to all stakeholders, there needs to be change of thought. And perhaps in the way that procedural issues are approached, as I mentioned before, but also in terms of, frankly, substantive analytical rigor, particularly in areas that have the most impact, like damages. I think we all know that there can be a lot more diversity of thought and experience and rigor going into that. So keep in mind that it's an area that is, everyone says, but not all tribunals follow this, we don't have precedents in investment arbitration. So you don't need to have had that long years of experience or whatever it is before. In fact, again, particularly where it comes to issues such as damages, we may benefit from having more diversity of thought in that respect. So all of these factors come together to say that there's no doubt that the limitations of the Code of Conduct really limit the generational change that we need. Thank you.
Juan Carlos, what do you think of this? How do you reply to all this?
Thank you, Katharine. First of all, still good morning. I want to thank Miami International Arbitration Society for the invitation. It's a great honor to be here with you and to University of Miami School of Law. I also want to thank the good Lord to having me put in the same side with Ellie. I don't want to be on the other side. Having said that, I think what we are hearing derives from a very misleading proposition. The proposition reads, a rule against double hiding will impede generational change. The first thing that to me sounds misleading is this is really not a rule against double hiding. This is a rule that looks to regulate double hiding, not to prohibit or ban double hiding. And it's a rule also that applies only to arbitrators, not to advocates or to lawyers. As Mélida was suggesting that you have to leave the law firm. It doesn't apply to the lawyers, to the attorneys, just to the arbitrators. But above all, it's not a rule about, it's not a discussion about double hiding per se. Really, the issue at hand here is independence and impartiality. It's really an issue about the legitimacy of the system. It's about the survival of the system. We heard this morning how we were discussing if the system is going to survive or going to still exist in the next 20 years. And one of the issues that was raised during that discussion was the issue of double hiding. So this is what we are dealing with. Third, I think the rule, or the proposed rule, does not introduce anything new, anything that is already in the system already, right now. It only makes explicit what always has been implicit. I mean, double hiding is just one of the many ways in which an arbitrator could be affected in his independence or her independence or impartiality. And any arbitrator has always had the duty to disclose any circumstance that could affect his or her impartiality or independence. So there is nothing new here. And finally, there is this romantic image that double hiding is going to change a system in which generational change happens, diversity happens, and this is going to be the obstacle to that. And you see this young lawyer trying to make that decision that Andrés was making us think about. But this is not the case. This is not the case. The system, as we all know, is dominated right now by a club. It is called a club most of the time, not my words. This can be, allow me to read some conclusion that In January 2020 was published this article called Diversity Deficit in International Arbitration, Investment Arbitration. And the conclusion is very telling, and if you allow me, I want to read it. It says, the operation of the prior experience norm means that the number of new entrants, both men and women, into the pool of existing arbitrators acting in ISDS cases is relatively low. As mentioned above, in the past 5 years, there were approximately 270 appointments to be filled in ISDS cases. These numbers are based on an average of 90 new ISDS cases each year. Of these appointments, only about 9%, about 25 individuals, go to arbitrators who have never previously sat in an ISDS case. And currently, the number of appointments going to female new entrant in the past 5 years is about twice that of the percentage of appointments that have previously gone to women overall. However, on the basis of women receiving about 23% of the new entrant post spots each year, which is the average over the past 5 years, it would likely take until 2050 for there to be gender parity in appointments in all new ISDS cases. If women were to hypothetically fill 100% of the new entrant spots, about 25 per year, it would still take quite a long time, about 30 years, to reach gender parity in all new ISDS cases. What does this mean? I mean, this romantic world in which we have all this generational change and all this diversity happening, and is going to be interrupted by this proposed rule, is simply not true. The reality is that the system as it is right now, there is no generational change, and there is no diversity. As a matter of fact, we can call whatever we want the system right now, but it is not diverse and it is not young. And the data further evidences that. It shows that this romantic image that Andrés painted at the beginning is simply not true. It is not the young practitioners who are really practicing double hatting. It is the opposite. If you read Malcolm Langford, who has come up with this double hatting index, the index, which is, by the way, designed to underestimate double hatting, not to overestimate it, shows that out of the top 10 double hatters at least in 2017, and the situation has not changed very much, 80% of those doing double hatting were above 55 years old, and they were all males. So it is not the young practitioners who is having to face this dilemma of having to choose between being an arbitrator or being an advocate. No, it is what was the phrase? The male, pale, and stale who are doing the double hatting. So that's why a rule against double hatting, such as the one we are discussing right now, will result in the opposite. It will prevent some of these eternal arbitrators who only change when they die, really, are going to be forced out of some cases, allowing for younger people and for women and for minorities to enter into this club. And I think the data shows what the real world is and not these romantic images we want to create. Thank you.
Thank you, Juan Carlos. Now that we've heard everyone's initial positions on this, we would like to take a survey. If you have the app, you can use it to see what you think. Do you think that a rule against double hatting will or will not impede generational change?
We're going to get the results of the vote, so vote carefully.
Keep moving.
Good job. 100 is the maximum.
Keep going. Wait a minute. There's
mean,
always
just
a
checking the math
technical
here.
difficulty when you come to looking at our side.
Very suspicious, right?
In our view, you had the easy side, by the way.
I think we're about to see the final results in a second, but they were pretty contested. All right, I think we can assume that it is almost 50-50 or 45-55, which is much more close than actually we thought initially. And what we're going to do right now is we would like to open this for questions. If you have any questions to our presenters, please raise your hand and we will give you the opportunity to ask questions. I have a few from what I've heard. And so I would like to start with Andrés. So Andrés, you said that financial stability is important, and that this rule against double hatting will impede this financial stability because someone will have to stop working on some cases and only working on some other cases. But we started our discussion talking and saying that this only applies to ISDS, and so that doesn't mean that someone cannot act as counsel in commercial arbitrations or do some other work, and then act only as arbitrator in ISDS. Why do you think that this still is a problem?
Thank you. Number one, the matter under discussion was exceptionally ISDS. I mean, the debate on the table was whether there was going to be a restriction or an impediment related to ISDS. Of course, if you take it or you transcribe it into international arbitration, it's a whole different, commercial arbitration, it's a different ballgame. But if you strictly stick to ISDS, I truly believe there's going to be strong limitations. And the limitations are quite interesting because, I mean, if you have young professionals that truly want to dedicate their careers to being arbitrators, then in accordance to Article 4, the restriction per se is not the fixed 3-year restrictions afterwards. The hard-cut restriction is that it is on a concurrent basis. If an arbitrator picks up an appointment, he concurrently cannot act as a lawyer or as an expert in any other matter related to investment arbitration. So if you actually want to pursue a career in investment arbitration, if you want to do other things, that's fine. But if you actually only want to be an arbitrator, you're going to have a huge barrier, and this is one of them.
Thank you, Andrés. Elisabeth, you seem to acknowledge that experience matters, and it's obvious to me that this Article 4 will impede some people obtain the experience that matters. So how doesn't this limit to double hatting impede young people to obtain that experience?
The proposition that we're making is simple. Maybe we have to define young. Is young under the age of 60 or something? Because the young that we're talking about here, and I consider myself young, by the way, the young that we're talking about here is not a person who's going to be sitting in an exit panel. The young in this implicit question about how can they gain the experience, the poor little birds. So we have a situation where you have counsel acting in a law firm, mixed partner, I want to say average 35 years old, continues practicing 10 more years, has 20 years of experience, has been a partner for 10 years, and then has the opportunity to make a decision. As to strictly the point of ISDS, we don't feel that the younger, that person in their 40s to 50s person, will be prevented from gaining experience if they make this choice, because main reason we think that is because a person who decides to commit to be an arbitrator will gain significant experience in the right hat, which is the arbitrator hat, and will have brought significant experience from past practice, can continue to act as counsel in commercial arbitrations like you stated, can continue to teach or whatever else they're doing. The only issue is that these cases tend to see the same measures over and over again with treaties that are very similar and many times the same treaty and sometimes related parties. And the prohibition is saying, the modified prohibition is saying, if it's the same treaty or the same measure, please refrain for the next 3 years.
Wow.
Is that after the case concludes, unless the parties agree? By the way, I think the code is not very well worded about which parties are the ones that have to agree, but we'll leave that for another discussion. So the point is I feel that the lack of experience, if the person doesn't have the experience, let's not blame it on the partial prohibition.
Oh.
I'll get back to that. But Mélida, you said, and I agree with you, that there are fewer women at partnership or more senior levels in law firms, and I think in general in the legal profession. But this seems to be a problem that's not created by ISDS or only applies only to ISDS. You know, it's something that applies and we have in the society in general and many other industries and professions. My question to you is, why should we sacrifice independence and impartiality to force a fix to a problem that is not an ISDS problem?
Well, I don't see how we sacrifice independence and impartiality by having a rule that fosters or allows having a rule that will not allow more women to participate. I think women are very impartial and independent, and the profession might benefit from having more women, particularly with respect to those two factors. So I don't see that is a way that you get by saying, so independence and impartiality. Independence, at least in the ISDS world, is generally getting to financial connection to the parties. I don't think that has anything to do with whether or not a woman has the ability to or is prohibited from being able to sit on a panel by a restriction that puts you at 5 to 7 years or 3 to 7 years out from being able to sit as counsel in a case. As a matter of fact, it has an adverse effect maybe on independence because you can't make any money during that time because you're being prohibited from sitting as counsel. I get where they were coming from by trying to frame it as you can't sit as counsel or an expert, and let's forget about the expert part for a minute, after you've served as an arbitrator. But then when you think of some of the other, the way they've framed some of these, so you can't sit as counsel in a case that's related. So if there is a commercial arbitration that maybe comes from a same treaty, or not a same treaty because it would be commercial, but comes out of the same nucleus, let's say, of facts, and I'm defining it for them to the extent they've not defined it, involving a party. Now, mind you, this involves subsidiaries of companies. Well, there are some corporations, conglomerates in the world where lawyers are hired, for example, litigation lawyers are hired by very different people who then within a subsidiary and including across subsidiaries are hired by very different people than who hire the arbitration practitioners and who appoint arbitration practitioners. So the idea that there's any connection between those such that there would be an effect on impartiality or lack thereof, it's frankly naive in terms of the way things really operate. Why should you not be able to sit in a case that involves a small subsidiary in another part of the world of a major entity that has a headquarters somewhere that, quite frankly, you don't even know about? I mean, obviously you perform searches, but the idea that somehow that's going to affect that, I think is a little bit naive. And so, you know, I don't see that as really helping. Prohibiting people from being able to get these opportunities is not really going to help independence and impartiality or improve it.
I think we have a question from the audience. Thank you, Mélida.
Yeah, hi, great panel. It's Richard Lorenzo. The question is, why are we so afraid of double hatting when all of the arbitrators that are presently on the arbitral Mount Olympus have all double hatted? So it's okay for them, but it somehow isn't okay for the folks that are up and coming today. So how do we explain that?
Who would like to? Juan Carlos, please. Thank you.
Okay, I think the answer is that the ISDS system is in a crisis, I think. And I think there is a legitimacy crisis. And I always have believed that arbitration is based on trust, the utmost trust. So it doesn't just have to be, it has to be like Caesar's wife. Not only to be good, but it has to give the appearance of being good. And this issue of double hatting is one of the issues that keep being raised to attack the system. So I think we have to do something about it unless we want to lose the system for good. So it's being forced on us. That's why that's my opinion.
Andrés, I have another question for you. You seem to, you said, I believe, that to act as an arbitrator, it is very important to have experience as counsel. But we have several systems where the person that's in charge of making determinations, and I'm thinking about judges, but we can think of other examples, they actually have no experience as counsel. And some systems think that someone is better prepared to be independent if that person is only in charge of deciding and has never had the need, the desire, or the experience as counsel. Could you please elaborate more on why you think that is important and why this limit would be a problem then to get that experience?
Yes. However, allow me 1 minute. I do have to answer to my good friend Elisabeth for an initial remark, because I truly am, I have to separate substance from air. She just said a minute ago that the more appointments you take, the better you'll be an arbitrator. I think that's the only thing we actually agree upon in this whole panel. Yes, of course. But how can you get better if you're not given the chance without paying an exceptionally high price? I mean, how can you actually gain that experience if you're not given that high price? And Elisabeth, fantastic idea is, okay, put an age limit to the arbitrators. 60 years old. 60 years old. I'm not going to even comment on that, but two things. Why do this? Why? Why limit or restrict bright minds? Just because we want to regulate something. And that's the biggest, or one of the biggest problems in our countries. Whenever we're faced with something that we cannot face, we regulate and regulate and regulate. And now, we want to forfeit the careers of potential arbitration professionals by putting an age limit just to actually substantiate double hatting. Enough said. Experience as counsel. I mean, what you just mentioned, Katharine, it's a way of seeing it, of course, but many states actually abide by that position, appointing non-counsel professionals, mainly, for example, university professors, et cetera, that don't come with a background. But I do believe that having experience as counsel is extremely key, because it's not only a matter of knowing the merits or the subject matter of the case, but you truly have to know procedure. You have to dominate how arbitration works. You have to know when something is correct and something is incorrect. So you cannot just simply abide by the merits of the matter when you have substantial procedural issues to abide by. So that's why I think, although I respect that certain candidates can be adequate for certain cases without having perhaps the experience in arbitration itself or its counsel, I do believe that in the vast majority of the cases, having experience as counsel is key. You cannot forfeit or undermine experience as counsel.
Can I just add one thing quickly before Elisabeth rebuts? And I'm not going to go to that point. I think Andrés had said very clearly one of the key things, procedure. I do not think, and something that is very pervasive in investment arbitration today, which is American-style discovery, I don't think that you can sit and evaluate those things unless you've actually experienced doing a Stern schedule, a Redfern schedule, dealing with the battles over that. It's those kinds of procedural things that unless you've actually gone through it, you don't fully understand it sufficiently. And another thing, judges are supervised, there are appeals. There are methods of dealing with their mistakes. There is no such thing in arbitration, and particularly investment arbitration.
Excellent. We have questions from the audience, but I know, Elisabeth, you want to answer. And I have a question for you that goes with what Andrés said, if you don't mind. I think, I believe that, the rule about 60 years is probably something with which you disagree that you said, but you did say that you have to be of a certain age. And you also said that you should be a partner. And are you, so why? Like, why do you think, I understand someone who is 20 years old, maybe you think is not ready, but in some law firms, it takes 15 years, 20 years to be a partner, and 15 years of experience seem to me enough to be an arbitrator, maybe as your first appointment. So how is that imposing age limits or these position limits do not impede generational change?
Okay, so let's start with what the proposition actually says. Impede. So we're all lawyers here, and we know impede is not hinder, damage. Impede is impede. And there's no rule that is going to prevent a generational challenge. And I would say, I'll speak for myself. I'm a young person, and I've gotten multiple appointments in the investment world. And I don't think that there was an age consideration when I was being appointed or not. So I honestly feel that we have to stick to what the question is and what the rules are. I thank you for clarifying. I did not say people have to retire at 60. That would make me quite unpopular in this room with some people. I said that the generation that will likely be replaced first are the baby boomers, who will be replaced by incoming Generation X and, of course, the millennials. And what I said is within the 62, 85, 90 years, there's a significant portion in that generation that was probably close to retirement or retired. Now, as to, there's two clarifications, one comment and one clarification I want to touch. On the clarification is that the example that was given by our esteemed co-debater on the issue of the litigator and the litigation counsel acting for a subsidiary and then a specialized arbitrator acting for another subsidiary, it's not what the code is regulating, because it's not regulating the law firm. It's regulating the individual. And the only thing that is being regulated is that same arbitrator, please don't go ahead and sit in another case in the next 3 years that involves a related party. And I think it's not a stretch to ask that same person, let's say the name is Peter, who was arbitrator in a dispute involving Toyota, to not take another case in the legal profession related to a Toyota subsidiary. It's not the entire firm, it's addressed to individuals. So I just wanted to be sure we understand the prohibition is trying to address is solely the individuals. Now, I feel that a perfect example of something positive that has happened in support of the generational change, as well as in support of the double hatting prohibition, is what happened with COVID and post-COVID. You have seen an enormous amount of senior partners retire, or partners retire from the practice of law and found their independent arbitration or arbitrator boutiques. There's more and more in the last 3 years. Every week there's some announcement at LinkedIn or GAR saying that so-and-so has set up their own boutique, which is entirely consistent with this proposition, which is when you reach a certain level of maturity in your career and you've gained all that experience, you've seen a gazillion red fern schedules before you reach that moment that I'm describing, then you make a decision. Is this the path I want to follow? It's not absolute. You will get lots of exceptions. You can do it different ways. But if you want to, even if we felt that the prohibition was a very narrowly absolute prohibition that didn't allow any escape valves, it's still a good choice. Now, it has lots of escape valves because, of course, the senior male stale did not allow this to be absolute. So it says if the parties don't agree, it's only for a year, it's only for 3 years, it's only if it's the same measure, it's the same treaty. So it's not an absolute prohibition, it's a modified.
Can I just say something quickly in defense of Petra? Sure. So it does, yes, it says it's not a law firm rule, but it says that Petra Peter can't act as counsel. If you're trying to get to issues of impartiality, how does that person sitting as counsel later on in an unrelated case affect impartiality? Because they're not sitting in judgment. They're not going to be able to cite themselves on something. This is a totally separate thing. This is acting as counsel, trying to be an advocate, just so we're clear.
I think Kathleen Pasley had a question.
Hi, I first want to thank Mélida for mentioning damages. I just finished teaching damages. Many of my students are here, so now they think it's marginally relevant. And I'd like to mention to Elisabeth that the next time I get an investor state appointment, I'm going to feel like now they're just saying I'm old, so thank you for that. But my point is so what we're seeing in practice, actually, and it's not because of Article 4, it's because of the general movement against double hatting, is not what was suggested by Katharine, it's the opposite of that. We're seeing people continue to act as counsel in investor state cases and then take commercial cases as arbitrator. So they're getting their experience as an arbitrator in commercial cases, and they're acting as counsel in investor state cases. And I've sat a couple times recently with lawyers who spend their career doing investor state arbitration for law firms, but they're sitting as arbitrator in commercial cases to get that experience, so when they do become old like me and they retire, they will have the experience. So how does that play? I mean, why do you have to have experience as an arbitrator in an investor state case? If you've got 20 years of experience as counsel and you've done 20 commercial arbitrations, why isn't that good enough when we all acknowledge that there is an issue with double hatting? It's not a nothing. Thank you.
Well, I'm not sure which side I'm sitting on now in answering this, but I will say there is something to be said for the fact that ISDS involves treaties and to some extent, or should be to a large extent, public international law, and an understanding of public international law, and an understanding that treaties are not contracts. Can I just say that again? Treaties are not contracts. They are agreements based on a broader relationship between states for political and economic reasons. They're not simple contracts. And I think sometimes there's a tendency to bring in the idea that, well, this is just two parties. And first of all, it's not just two parties. They're not the parties to the contract. You had two states make the treaty and give another party a right to bring a case. So I think that those are important distinctions.
Absolutely. Thank you, Madam.
I think that's a very good question. But there's also one thing. Investor state and commercial are two different animals. Although it's true that you have 20 years as counsel or arbitrating sitting as commercial arbitrator, there's as counsel. Okay. The biggest difference, and one of the biggest difference, number one is what Mélida just said. It's about the treaties. Number two is truly knowing and understanding international law. In commercial disputes, you will have commercial disputes that normally don't fall out of the contract. In arbitration, in investor state, international law, international politics, the way states behave, the way states actually exercise their sovereign rights, it's extremely complicated and different in connection to contractual claims. That is why normally there's a subtle but very important difference between investor state claims and contractual claims, which are not the same. No?
Please, Juan Carlos. Thank you.
Yes, but I think you are absolutely right. I mean, there is always going to be a first time, that's for sure. Your first appointment as an investment arbitrator, that's for sure. But this is probably one of the few areas in the world that having gray hair helps. It's a good thing. You have to earn the trust of the parties. How do you earn that? Well, with a career. States are not going to trust a case, or the parties are not, one of the parties is not going to trust a 20-year-old to resolve an investment dispute. So you can get your experience somewhere else, and that will always be your first time, and then you can make a career out of that. So I think you absolutely nailed it. That's the way you get the experience to get appointed.
Thank you. Well, now, unless there is any other question from the audience, we're going to switch to final remarks from each of you. And I would like to give each of you 2 minutes to please conclude. Thank you. Andrés, please.
First of all, it's been an absolute pleasure to be here and discuss, and thank everybody for bearing with us for the last hour and a half. I just want to conclude by actually thinking, why are we discussing this? And why are we actually listening to this? Because there's an underlying question just above all of this, is that, do we want the system to survive in the future or not? And if it's going to survive, clearly, we cannot regulate or force regulations that are going to restrict or limit few generations to enter into the field. It just makes no sense. We can argue it one way or the other. We could actually provide several reasons, but any factual matter that could actually comes to restrict the ability of new players to enter the game, the only thing that will happen is jeopardize the system that is already being questioned. So allowing new generations to come in is the key to avoid the system to actually go down. Keep regulating, keep on restricting, and keep on limiting the rights of new generations will only speed up the matter and will never take us where we want. And we all want arbitration to survive. Thank you.
Thank you, Andrés. I'm going to read one question that we got on the app in case that you can incorporate it in your conclusions, okay, and address it. The question is, how do you balance the desire of arbitration users to have an experienced, credible panel versus the interest in generational change? And so, Elisabeth, I don't know if you want to go first with your closing remarks. Thank you.
Okay. So there is, first of all, one thing we do agree, which is that the system is compromised, that there are many criticisms, and that it is in the interest, and we heard it all this morning, the first speaker, the first debater this morning raised the question about what double hatting was doing to the institution of ISDS and to the credibility. And so we heard the challenge that it represents and the criticisms against it, and we all agree, I think, that we want the system to survive and to work well. And you design rules to improve the system. And the rules are designed for the general rule, not for the exception. There might be very exceptional situations where it would be absolutely logical that this particular arbitrator in this particular case could double hat, or even though it's the same measure in the same treaty, there's a reason it doesn't represent a conflict or inherent issue, ethical issue. But the rule is there to ensure that there is transparency. And that is one of our main propositions. There was nothing in our research, in the data, and in the facts that we have brought you today that would suggest that this temporary, partial prohibition with all the exceptions and escape valves it has would prevent the generational change. And there is for sure nothing suggesting that until last week, when the code was in nobody's world and it didn't exist, let's say, there is nothing suggesting that without the prohibition, the generational change was happening perfectly fine. Thank God there was no prohibition. Anything that has to do with the generational change, and that is the main point, is we are not in any way preventing. And to suggest that this is a binary proposition about whether we allow the next generation or we don't, it is not. The question we're being asked is, if there is this limited prohibition, is it going to impair a generational change? And that is where we feel that there is nothing that supports that. And even if we were to argue that there might be arguments in favor and against, if we have to put this in a balance, that maybe the double hatting modified prohibition somehow challenges some of the generational change, that has to be put in a balance with the transparency and survival and integrity of ISDS. And when you put that in a balance, this will significantly outweigh the potential tangential arguments being made that potentially generational change will be a little easier if we don't have these rules.
Thank you, Elisabeth. Mélida, your turn.
I just want to point out that we're at 50-50 now.
Yes. Actually, this happened like in Venezuela, you know, we won, then the lights went out, somebody took over the technology, we come back in the room, the thing is completely reversed, then they announce it so everybody knows what's going on and start to influence the vote because people want to vote for the winner. So of course they reverse the vote, and now finally the truth is coming out, but we don't have enough time to reach back to where we were.
I think the many commissions that have examined the voting in the United States in 2020 have shown that those machines from Venezuela did not change the votes.
Now we know where we sit on ISDS as well.
Should I finish? I am only going to repeat what I said, so I don't want to prevent someone from being able to ask a question. So I would just say that when you think about it, the reality of preventing someone who is sat maybe in one case, one ISDS case as arbitrator, from acting as counsel in unrelated or possibly, you know, first of all, when have we ever heard of someone only bringing a claim, or an investor only bringing a claim for FET? I mean, the way these rules work, you can't sit in one where you can't act as counsel in a case where there's an FET provision. That doesn't make any sense, because investors bring all the claims, and then maybe they filter some out later, but you know, that just doesn't make practical sense. So the reality of saying that you're going to have a rule that prevents someone who sat as an ISDS arbitrator from being able to sit as counsel in either commercial cases or cases that may involve one of these claims, I think it's just absurd.
Thank you, Mélida. And I'm going to give your 2 minutes, but I think there was a question from the audience. Someone. Yep.
Sorry. So I guess my question is for this side of the aisle. Oh, sorry. I'm Sahar Hosseini. I'm currently doing my master's in international arbitration. And I appreciate you guys for coming here and discussing such an interesting topic. As we understand, Article 4 is set out to salvage the reputation and the legitimacy of ISDS. But we see a little evidence that that double hatting actually undermines the outcome to any significant level. In fact, we see only a small handful of cases that sitting arbitrators acting in other cases would actually run into perceived lack of independence or impartiality. But I believe that such a restriction would impede the right of autonomy. It would actually restrict someone's ability to make a choice, and I think that that's of any interest. So I guess I'm interested to know what your opinion is on autonomy. Do you think that this will have a detrimental effect?
Who would like, if you can take that, it's great. Thank you, Juan Carlos. Sorry.
Okay, now, I think the rule, as it is drafted right now, allows the party to waive that problem. So it is not against the autonomy of the parties. They just have to disclose it, and if the parties agree to waive it, there should be no problem in appointing.
But that would require both parties to consent to that, and that's not always going to be the case.
That's usually the case, yes.
Yeah, and I think also as new practitioners, that is really important to be able to make that choice. And decide how you would like to proceed in this field. I think this would also have a huge impact on ongoing disputes as well in domestic practice, and I think it also significantly causes a significant harm in the long term. I think on the balance of if you're balancing the right of autonomy, the right to make a choice as an arbitrator, as a practitioner, and on the other side, if we're looking at the potential harm, I think the right of autonomy is weightier. So I think it's important for practitioners to be able to make that choice, and I believe that Article 4, in a sense, it actually makes it much more difficult to enter the field and makes it very much more restricted.
Thank you. I think Andrés has something to say.
Debate aside, I think you're absolutely right. You're absolutely right, yeah. We did not bring in the freedom to freely elect, or the right to freely elect an arbitrator because it was not directly related to generational change. But your point is dead on, absolutely dead on. You cannot restrict in any way one of the main pillars or foundations of arbitration, which is actually to freely elect. And the choice, it doesn't matter of age, gender, diversity, whatever, experience included, the right of a party to freely elect its arbitrator. So that's a cornerstone, irrespective of what we're debating here today. I am 100% in agreement with you.
Would you like to answer to that?
Yeah. I just disagree with that. I mean, the right to appoint your arbitrator is not absolute. I mean, you cannot appoint anybody you want. There are certain rules, and this is just part of those rules. So it's, and this is part of my conclusion, if I can go ahead. It's really nothing new. I want to repeat and emphasize that. I mean, these are issues that the rule is trying to address issues that has been already litigated and decided. So there is nothing new in this. And this is really an issue about legitimacy of the system. The system is under attack, and we have to address this issue of double hatting in any way we think possible, because otherwise the system is going to disappear. We can disagree on the details. We can disagree if it is 1 year, 3 years, 2 years, I don't know. When do we start counting the years? All that. But we have to address this problem. It is a problem. According to the statistics and the data we were able to find for this particular debate, up to 58% of the ISDS cases involve double hatting. So we do have a problem, and we have to address it somehow. And all the opponents of the system are using double hatting as one of the main weapons to attack the system. So if we do know nothing, probably you will have no system for the young practitioners. So it is either a limited system or no system at all. And furthermore, we have a system right now that doesn't allow generational change. So it shows that there is really no relationship between the two issues, a double hatting regulation and generational change. There are two separate things. I think it's really, to quote Shakespeare, much ado about nothing. And that's it.
Thank you. Well, and I think that's it. I wanted to close by thanking all of you for being here today. Thank you very much to MIAS for organizing this, in particular, Richard Lorenzo, Luis Onaten. Thank you, Don Hayden. Thank you, and I also want to thank very much our speakers. I find debates are very interesting and much more fun. It forces us to think and hear different positions, and we know that these issues are never crystal clear. So thank you for preparing, and thank you much for engaging in the discussion. Thank you.
And thank you, Katharine, for an excellent moderator.